In this paralegal practice tip, I am going to briefly go over some bankruptcy basics. And when I say brief, it's going to just go over some basic considerations when working in bankruptcy law as a paralegal. First, to understand there's debtor and creditor bankruptcy. If you work on the creditor side, you'll be working for a law firm or organization that the debt is owed to, or debt is owed to. If you work on the debtor side of bankruptcy, then you'll work for a firm or an attorney that is representing the person or organization that owes someone or several individuals or companies money. Now, when you work on the creditor side, it's important to understand proof of claim and also filing deadlines, because a proof of claim is actually what a creditor must file in order to receive any payment within a bankruptcy. Like if there's any distributions that will be made by what's called a trustee. This is pretty much kind of like, for lack of better words, like a manager over the bankruptcy. When those distributions are made, they're made by the trustee, but they're only made for creditors that have filed valid proof of claims. So that's extremely important, because if a creditor does not file a proof of claim, they don't automatically get paid on a case just because they're owed money by an individual organization that's filed bankruptcy. Also important to keep in mind what a voluntary and an involuntary petition is. A voluntary petition is when a company or individual, they initiate the filing, the bankruptcy's filing. They file the petition on their own. Involuntary is when a creditor actually files the bankruptcy. You'll typically see these in large companies. You'll see these in Chapter 11 filings. Also, it's important to understand the different chapters of bankruptcy. You have the Chapter 7, which is considered liquidation bankruptcy. You have Chapter 13, which is a reorganization. Chapter 11 is typically for individuals that make over a certain amount of money, or for companies, and it's similar to the Chapter 13, where it's also a reorganization. And then you also have Chapter 12 bankruptcy filings. These are rare, but these are typically filed by farmers. Now, when you work in debtor bankruptcy, you'll be preparing what are called statements and schedules. And what this is a listing of assets and liabilities of the debtors. How much is owed? How much assets do they have? Do they have real estate property? Do they have cars, jewelry? All these things will be included in assets, and then liabilities will be all those debts that they owe on. And the discharge, you may hear this terminology, and this is actually extremely important. A discharge in a case is when pretty much it's completed. It's not closed, and that's important to understand the language of a discharge and a case being closed, because a case can be discharged, but it may not be closed yet. A discharge is the court's order that relieves the debtor of any further obligation on debts that were included in that bankruptcy filing. So this was a really basic and brief overview of bankruptcy, but if you're looking to go into the bankruptcy, then it's important to determine if you want to work on creditor, debtor bankruptcy, and then also to understand the different chapters of bankruptcy. There's the Chapter 7, 13, 11, and the 12. And again, the 12 those are rare, and those are for farmers.